Okay, sorry about that. Okay, we think we can start now. All right, hello everyone. Good afternoon. So my name is Olusa, and I will be hosting this.
Sorry about that. Okay, we think we can start now. All right, hello everyone. Good afternoon. So my name is Olusa, and I will be hosting this. Sorry about that. Okay, we think we can start now. All right, hello everyone. Good afternoon. So my name is Olusa, and
Can you hear me? Okay.
Yes.
All right, I think it's better now. All right. So very quickly, it's coming back again.
yes. All right, it's better now.
Thank you.
Right.
It's
So very quickly, it's
recording you and then
Yeah.
restating.
thank you.
Just say stop recording for now. Just stop recording and then
That should be fine.
stop recording and then
All right, can you guys hear me?
yes.
Stop recording and then.
Yes, we can.
Okay.
All right, can you guys hear me?
Still back on.
Yes.
Yes, we can.
Okay. Still back on. Yes.
Audrey, if you try to stop recording and start again, if that didn't work, maybe you can just leave, then come back again.
All right, I think we're good now. Yeah, sorry about that. And a lot of time has been taken. So let's see how much of what we can do with the time we have left on our hands. All right, we have Lucy here with us. And she'll be helping us with this workshop, very important workshop to create awareness, to create to prevent more chaos in our community, and to provide empowerment to our community. And today's legal lunch and learn is focused on family property and division. And so who do we have here is Lucy. Lucy is one of or rather Barrister Lucy is a senior associate and managing lawyer in the family law division at Osuji and Smith Lawyers. She practices family law, including divorces as well as employment and labor, real estate, civil litigation, and corporate matters. So beyond her legal practice, Lucy here is deeply committed to community advocacy. She serves as our board chair here at Ruth House and volunteers with Calgary Legal Guardians at the Women's Center of Calgary, supporting women, children, and families, particularly those experiencing family violence. You can see that she's well equipped with all the knowledge that we need for this workshop today. And we are really, really happy to have you here with us. So should we go straight into it? The topic for today, again, is family property and division. I will enjoy each and every one of us to drop our comments on the chat box if you have any questions. And when it's time for that, we'll go into it and satisfy your needs. All right, Lucy.
Good afternoon and Happy New Year, guys. I'm so glad that we were able to have you all join today. My name is Lucy Dialemewanu, and thank you again, Ohoha, for the introduction. It's my pleasure to always be on here and to put in my part in terms of circulating information to various communities. I understand that today, of course, with the weather and everything, people are caught up with, attending to emergencies involving car emergencies, but I'm hoping that we can have a lot of discussions today so that it will be a productive use of our time. And if we have to go until 2, I did allot time for that already.
Thank you so much. So,
okay.
ready.
Yeah.
Go ahead.
Well, today's discussion, we had to break it into 2 parts, which means we'll carry out part 1 today and then part 2 for next month. It relates to property, particularly property division in the province of Alberta. And the reasons why I'm focusing on Alberta is just because when it comes to family law practices, it is provincial. But the Divorce Act is a federal statute. So when we rely on the Divorce Act in terms of separation, validity of a marriage, parenting, child support, spousal support, we deal with federal provisions, and Ontario can also rely on those provisions. But property division relies on the Family Property Act, which is a provincial legislation. I'm going to wait for your questions, and then I respond accordingly. You're muted.
Okay, so before people just have the questions and are ready to type in their questions, I have some questions that I feel that we get from our clients and people who are really getting to decide that they want to go for divorce. They want to go into that space, and they're trying to navigate how to go about it when it comes to family, property division. So the first question I have is, in your own experience, what tends to be the most challenging part of property division for families going through separation?
Well, I feel like one challenge that I find common, particularly among the immigrant communities or families, is understanding what the rights of property is, and also how property division works. One thing I'd like to note is that when it comes to the division of property, marriage, like civil wedding and having a certificate of marriage, is not the foundation or the main requirement. The relationship is, and the aspect of the relationship that relates to cohabitation, meaning that if you were married and you do have a certificate of marriage, good, you will have that entitlement and right to share in property. And even if you are not married, meaning that you didn't conduct a civil marriage, but you were living with this person in a relationship for 3 years or more, and you do qualify as adult interdependent partners, i.e. common law, you will still have that right to share in property. The Family Property Act applies to the different dynamics of the relationship. As long as a cohabitation is established, you will have that entitlement. So when people come and they're like, oh, we're together for 17 years, but we're only married for 5 years. So I guess I'm just looking at the 5 years, what the person had. I'm like, no, we're going back to the beginning of the relationship. Yes. I've realized that people are becoming increasingly aware of what those rights and entitlements are. And it has also widened the understanding of how to go about it. But then another challenge that I find common is compiling property items. When we look at the Afro-Caribbean communities, because most of us are immigrants, we do have assets and liabilities of businesses outside of Canada. So when it's time to divide property, there is that question of how do I start looking at what he has in Nigeria, Cameroon, Dubai, Middle East, wherever it is. How do I make sure that the person is being truthful regarding what they disclose to me and to the court, and they're not hiding things? That is the main challenge: disclosure, compiling of information, getting to know exactly what the other person has, determining the values of it. And because we have to look at the duration of the relationship and determine what the value of property is for that duration of the relationship, it's also a challenge, just because it would take a little bit of time and could be costly to the client.
Okay, so if I get you rightly, what you're saying is that couples, people do not need to legally be married before they can access properties, even at the point of separation or divorce, right? So for
Yes.
cohabitation, is there like a timeline, or once the relationship is already defined, then that qualifies it?
Well, under the family law practice, we do have two types of relationships that are recognized in terms of determining not child support. Child support is automatic. If there's a child, there's support. But things like partner support, spousal support, and property, the two forms of relationships are legally married with a marriage certificate, or not legally married, but there's a cohabitation. That's different from what the immigration system looks at. So I'm going to focus on the family court system.
Okay.
For parties who are not legally married and they don't have that marriage certificate, whether from Canada or outside of Canada, they must have cohabited for at least 3 years to qualify as common law.
Okay.
We call it adult interdependent partners, but in layman terms, common law, that's what is used most times. If they can establish that duration of cohabitation and that it has been 3 years or more, then that entitlement has started building up, and they have the same rights as anybody who was married, right?
Okay.
Yeah, so there's a timeline factor, which is a 3 years period.
Okay.
To understand more about common law relationships, we do have a statute called the Adult Interdependent Partners Act, Adult Interdependent Relationship Act, sorry.
Okay.
And if they're in common law, they're referred to as adult interdependent partners. If they do separate, they're referred to as formal adult interdependent partners. And yeah, that's for the sake of property and support, partner
Okay.
support. Yeah.
Okay, I think that's very clear. I think, okay, so going on, so what do we do about cases where one person in the relationship, in the marriage or relationship now, is working, it's the one bringing in the income, and then the other person is more like the domestic housewife, the person in the house, or rather, it can be both ways. The woman is the one working and the man is the one not working. Are the shared properties still equal, or how does it go?
That's actually a good question because it comes up a lot. And even when we look at past cases, it does deal with that. However, when it comes to division of property, the standard principle is that you have to look at everything that both parties own in their sole names or joint names and tally it up, meaning that you're creating property charts to say, husband has this, assets and liabilities. So if you have a home, the value of the house is going to be under the asset column, and then the balance of the mortgage is going to be under the liability or debt. And you add up what the wife owns in her sole name, there's joint property. And then that is the standard. You add and you divide. But there are exceptions, which now brings us to the case-by-case situation. However, one big thing that plays is the duration of the relationship. If you were with somebody living together, whether you're married or you're not married, as long as you've cohabited for a lengthy period of time, I would say more than 10 years. The worst is if it's more than 20 years. One thing I would say is that you're likely to do 50-50, regardless of who contributed to the purchase of those properties, regardless of who contributed to the increase of value of those property items, regardless of who was financially responsible for the family. 50-50.
Okay, I have XT. I don't know if I called your name properly. I'm sorry about that. Asking, because I was going to ask this question. What if it's just the person's name on the documents? So she's asking, what if a car was gotten together and it's one person's name on the documents? What happens?
A car value is divisible, is part of property. When we deal with separation matters, if the parties were legally married, then we file a statement of claim for divorce and division of property, which is a commencement document. However, if the parties were not married, they don't need a divorce, so they might need to deal with other things, which is why they will need to file what we call a statement of claim for division of property. There's it's a commencement document as well. Both parties are going with the primary rule of division. You have to provide everything you own, the other person has to provide. And to do so, we use a disclosure statement. We have templates. You have to provide yours is sworn, like an affidavit, the other person provides. Any property that is in one person's name, whether it's a bank account or house or car, investment, including TFSA, stocks, anything that they own, right? Including jewelry that they own is subject to division. It means that it forms part of that property, which has to be valued and has to be divided. So to ask this question, if there's a car that is owned by husband and wife alone, we look at the total value of the car, whether from Facebook Market or Auto Trader, something, to determine what the car could be worth at the time. Then we'd also look at any financing balance that is left, because if there's money owed on the car, it means that you cannot divide the full value of the car. You can only divide the full value minus the debt, right, to get the net value. But the car is subject to division. That's what I would say. As long as it was purchased during the relationship, the cohabitation relationship, or the marriage. Anything that was acquired during the cohabitation period into the marriage or things like that is subject to division. So, XC, in this case, if the car was bought during the time of the cohabitation relationship or during the marriage, it will form part of property division, whether it's in one person's name or both parties' name. You just need to determine what the net value of that car is and divide it by half. That people who own property before they got into a cohabitation with someone or before they got married to somebody, we will now look at each property to say if there was a time of ownership that fell outside of the relationship, it will be exempt. And on the forms that we do for property disclosure, there's exemptions that you will claim. You could have a car from your grandmother that was a gift or an inheritance. You could claim an exemption for that, meaning that you're not wanting to share with the other person because it was gifted to you as an inheritance. You could have some money that you inherited from your parents or your grandparents when they passed away. You could claim an exemption to that. And the other person could argue it for whatever reasons they have. But most times when it comes to inheritance and gifts from third parties, they're likely to succeed as an exemption.
Okay.
Investment properties as well. If I have a home with my husband and then my husband has 5 houses in Calgary that he's renting, well, I'm sharing in those. So everything has to be tallied.
Okay.
And the person who is claiming an exemption, meaning that they want a property to be kept out of property division, is the one to prove it. they have the burden to prove as to why that property should not be divided.
Okay. So this relates to the next question before I get to the question. So if, many of us are immigrants and most of us have built our lives back home even before coming to Canada. So what about situations where a partner feels that the other person is not being sincere enough or open enough about the properties back home? Is there a way our system here can checkmate that?
That is a hard one, and most of us who deal with outside of province or outside of country properties face that challenge. And the property could even be in the US, but we have jurisdiction.
Okay.
And when it comes to the court systems in our various provinces, that jurisdiction is limited to where they're founded. For example, the Alberta courts operate within Alberta, and that jurisdiction is limited here. So if there was a matter in Ontario, they'll hardly get involved, which means you have to go to Ontario court. When it comes to properties that are located outside of Canada, you could compel disclosure, meaning that when we do the initial exchange of financial disclosures and Schedule A is very detailed. It lists all categories of property. It's a template document, so nobody has to prepare from scratch or guess it. We have templates for those. We just need to complete the dates of acquisition or values and stuff. If you feel that the other person has not disclosed everything and you have evidence of that, or you have a neighbor or a sister back home who can tell you for sure that they own that property, then you can have your lawyer or by yourself apply for a court order compelling that person to disclose it. If they fail to disclose it and there's evidence that the property exists and it's in their name,
okay,
they could be subject to penalties by the court, financial penalties, meaning that the court could make an order saying that they are liable for $100 per day until the day that they provide the documents of this property. When it comes to valuating outside of country properties, the courts in Canada have a limitation on that, just because they don't know what those properties are worth. In Canada, if you pull up a property, you can get the full information from land titles. You can even do a property search and get the land title certificate to know who owns it, when it was bought, blah, 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 all of those things. You can get an appraisal done. You can get a comparative market analysis done to know what the value is. But when it comes to a property in Cameroon, it's a word thing.
Yeah.
If you tell the court that the property, if the man tells the court that the property is worth $2,000 and the wife is like, no, it's worth $5,000, both of them have to make the effort to bring documents to show those values.
Yeah.
Right. But in terms of disclosing it, there are ways to go about it. If you do have concrete proof that the person is lying and those properties are existent. But you also have to be sure that the properties are in their name. You don't want to get a court order to compel somebody to disclose something that is owned by 10 of their brothers and they have just 1/10 of it. Or the property is in their grandmother's name and you're thinking it was given to the guy, but it wasn't because the grandmother is not dead yet. Right? So it's good to have your details clear, and the lawyer will always advise you on what can be done in order to facilitate disclosure.
Yeah.
The court takes disclosure very seriously.
Okay, but at least I'm happy to hear that there's a way out.
Yes, there is.
That there's a way out to get shares even to our properties back home. That's a good one. So let's go to next question. It says, let's see, what if during separation one person sells off the properties or stocks, or just before getting it, and or just before it gets to divorce? So you're at the point of separation, you're at the point of divorce, and then you know that there's going to be a point where you have to split your resources. right? And so one person tries to play smart and chooses to sell everything off before that that process. What happens?
All right, before I get to that question, I would like to clarify that separation is not divorce.
Yes.
Separation is when both parties establish the intention that they do no longer wish to represent themselves as couple, be it whether they were partners. Can we stay? That's how we call it in common. Can we stay? Concubine or whatever. Or if they were married, they have made that intention known to each other that they no longer wish to represent themselves as a couple. We have a separation date. It could be physical separation, meaning that one person moves out of the family home, or one person moves to the basement while the other person remains upstairs. But sometimes parties cannot afford to stay in separate houses, which means that they will share the same house, but they could be in separate rooms. The first thing when they come to us for consultation, I ask them, what is the date of separation? They'll be like, oh, he hasn't moved out. I say, no, but when did you guys have that understanding that this is no longer continuing as husband and wife? They'll tell me, but they're not divorced yet, because divorce is when you get a divorce judgment. So if at the time when you separate and you know that date, it could not be a particular day, but maybe a month, say at the end of September, and that person at that separation period started selling stocks, trading them, cashing out on GICs, or transfer property to his relative just because he feels like they can escape. We're doing tracking. We go back. If the property or property item was sold or transferred during the time of the marriage, we will still find out what happened to the money. And if the money was not used for family, your family,
Yeah.
then that person owes you a credit, which means that your share of it, the value of that, will have to be adjusted in the general property division.
Mm.
Most people try to play, and this is very common. Nobody wants to give out money. They say, oh, it's mine, I work hard for it. But when it comes to relationship, I'll say a majority of the time, both parties contribute in different ways. Yes, one person could be the financial provider and the person financially responsible for the family. They go to the oil fields, they work hard, but there's a reason why they're able to do that. It's because the other person is at home holding down the house.
Yeah.
Even if the other person is working, there's a reason. If they have kids, there's a reason why those kids don't go hungry while you're away working. So you can't say the other person did nothing.
Mm-hmm.
Because if they were a homemaker, they did a lot. It's just different from what you did. And they have the same rights and entitlement to everything that is owned by that family.
Yeah.
They don't have to put money into something to benefit from it, because one way or another, they contributed to the growth of that family.
Okay. That's satisfying to know. Yes.
Mm-hmm.
I know many of our people, would try to want to play smart sometimes. So it's very satisfying to know. So let's get to the other side of it, where there are debts involved. And then you are the points of divorce and sharing properties. What happens to the debts? Are those still splitted?
Yes. When you're going for the assets, you're taking half the debts as well. It's a hard pill to swallow. Because this is not a question that comes up only from our Afro-Caribbean or immigrant communities. It's also a very general question. You'll be surprised at how many people are not familiar with the principles of property division in Canada. And they get to find out when they go to the lawyer's office after they separate. And then they think 20, 30 years, 40 years back in their life, and they're like, oh my God, I should have paid attention. I should have made better decisions. I should have been asking questions, because now I just found out that my husband or my wife has $300,000 in debts to CRA, or they owe somebody money somewhere, and I'm responsible for 50%. So yes, assets and debts are divided. The financial disclosure documents that we compile includes all property items categorized in terms of assets, the values, but also include debts. So whether it's personal debts or corporate debts, and if you own a business, registered business, incorporated, not incorporated, those things go on the documents. Secure debts like mortgages, and other things, home equity, line of credit, unsecured debts, credit cards, the generic line of credits, anything that it's compiled. That is how we come to equalization. Yeah.
So even if it's incurred by one person?
Yes. Now, the person who is saying that I don't want to be responsible for the debts has to say why. But the standard is to add up everything and divide. When it comes to debts, one person could say, I don't think I should be responsible for this particular debt. That's after we've compiled, because there's a process that goes into it. And me being the lawyer will ask them, why do you say so? We will not get the statements. You're not just saying, oh, I have this debt. You're providing statements. And we do go as far back as 6 months from the date of separation. If the person has corporate businesses and stuff like that, they also have to disclose for their corporations. Disclosure is very deep. The document is this huge, I'm telling you. So you have to give out everything in order to be transparent. If the wife or the husband says, I don't think I should pay this, let me take a wild example. The husband or the wife owes 100,000 to somebody that they borrowed, right? And the wife is like, I don't think I should pay this, I should share this debt. I'll say, why do you think so? They'll be like, well, I never saw any part of that money. I don't think it was used for our house. I don't think it was used to purchase anything in our home. And from the bank statements, you can see that the money was disbursed to different things that did not concern my family. So it should be his debt. That's a valid position.
Yeah.
I've seen bank statements where the husband, I'm going to use the husband, and this is no offense to the guys, but where the husband has 40,000 in debt as per the statements. But when we start looking at the statements, he used 20,000 of that money to like buy things for his girlfriend. Well, the wife is not going to pay half of that.
Yeah.
So it's going to be your debt alone. Yeah.
Yeah.
Which is why we go through thoroughly to determine what falls under family debt and what doesn't. Once we make the determination, just like we do for the property asset value, we'll now say, okay, this is the ballpark of what is to be divided.
Okay. So I know that you're totally involved in just the legal aspects of, the whole process. But sometimes, not even sometimes, all the time, divorce process can really be very overwhelming. And so with our clients, people can really get, emotionally affected by divorce. So so it can be very unsettling, right? Because you understand what I'm talking about. So what are one of the first things one of the first education tips that you think our people should know once they are stepping into this process?
Okay. I'm a lawyer, and of course I want to make money. And I work for a firm that requires me to make money. But I'm also an advocate for justice, which means that as much as I'm looking to increase my billable hours, I'm very particular about access to justice and having people understand what resources are available. When I consult with a client, my personal practice is I review your circumstances. That's if they come to me for a consultation through my office. I'll review your circumstances, review how far things have come. If the parties have started an action already, then of course documents have been filed. But if they're freshly separated, I would tell them what the options are based on the circumstances, meaning that we're looking at the duration of the marriage. When did you start living together? When did you meet? How long were you married? All of those things, the background. If there are children, definitely parenting and support. Are you asking for spousal support if they were married? If they were not married, are you asking for partner support? Because we use two different terms for this. Is there property? Once I get that basic, I provide them with options. That's because options are good to determine the financial part of it. It's a lengthy process, like you mentioned, and somebody could start strong, but over time, they kind of drain out of resources. That's normal, whether it's for the man or the woman, whether it's family law or whatever area of practice. So knowing your financial options are very important. If it's somebody who was financially dependent during the relationship, meaning that they don't really have a consistent job or they cannot sustain themselves right now, meaning that they want support.
Yeah.
I will tell them, do you want support right now? Yeah. I'll say, okay, try to contact legal aid. Because if you're approved for a certificate, I could discuss with my office to see if I'm able to take your certificate, right? That is done on a case by case, but they will know they have the option of consulting with legal aid. It's by phone. You phone them, they ask you questions. If you qualify, they will give you a certificate that a lawyer will use to represent you. That way you're not paying out of pocket. The lawyer submits the time to legal aid. It saves you the stress of dealing with that financial responsibility right away. If they don't qualify for legal aid, because that could be possible that they don't qualify, even though they're low income, and there could be a lot of property that the family owns. So legal aid has its process, which is outside my control, unfortunately. I'll tell them, go talk to legal aid, come back to me and let me know what they say. If they go talk to legal aid, they don't qualify, they come back, I'll now take on that personal judgment and, of course, upon consulting with my law office to see what options we could have for this person, depending on the circumstances too. Law firms are able to come into those arrangements, right? At the end of the day, we acknowledge that most people don't have money to pay a lawyer $350 per hour, $400 per hour, right? So it's now left to the firm to decide. But if the client qualifies for legal aid, of course, a lawyer will pick up a certificate and represent them through that certificate. Those are the options. Another option is the client could decide to become a self-represented party, meaning that they want to go through the process themselves. There's so many resources available at the courthouse for family law matters. We have the first step, which is the family counselors. They are at the courthouse. If you go there, they'll help you. They'll help you to explain documents, fill out documents, schedule court dates, where to file. They're like information for your information purposes. They don't represent you in court. However, they could help to facilitate your communications with the court. We also have resolution services at the courthouse. They do the same thing as well. We have different avenues of the court, like resolution counsel, who are lawyers, but they're particularly working for the court. They work for free. If you want to be self-rep, you can go through that process. You won't pay a lawyer, but you will still get a level of guidance that is sufficient to address your matter. If an agreement is reached out of that meeting, it will become a court order and it's enforceable. And that's through the court. And then you could go to mediation. That community mediation places in Calgary or Alberta in general, who can sit with both parties, discuss the issues, come up with an agreement, and then send the agreements to lawyers to expand on it. It will reduce the costs. But yeah, those are the different options. And I take it as a personal responsibility to discuss it with the client. Then let them make the choice of what they want to go with.
Okay, so really from what you said, I'm really happy that Ruth House as an organization, one of the things that we do is provide referrals to all of these resources that you've mentioned to our clients. We'll just let them know, okay, we're going to refer you to legal aid, to all of this, so that you can get first-hand information as to how you can go about the whole process. But one important information you've also given out right now is that it is very important that we dot all our I's and cross our T's, start enlisting our properties, things that you know you share with your partner, number of kids, everything that you know that you have within your space. You start gathering your documents, you start looking out for this information, because time is money. So when you speak with these lawyers and you know that funds are limited, if you have this documentations on ground, it hastens the process, right?
Yes.
Yeah, okay.
Yes.
So
on that point, for those, if there's anyone here who has consulted with me before, they might tell you that I will give you documents in my consult. It costs me nothing to go and download those templates and give it to you and tell you exactly how to complete them. Because when you have that startup, it helps you to move forward. Even if you don't retain my firm, that's fine. But as a personal practice of mine, I will give you the template. I will give you the notice to disclose document so that you can compile all financial disclosures, because you need it. I will tell you where to find provisions in the Family Law Act, which will apply to parenting, child support, or the Divorce Act. You know, Section 18 of the Family Law Act talks about parenting and best interest of the child. That same principle is highlighted in the Divorce Act, Section 16, which deals with parenting, child support, spousal support, relocation. I will tell you where to find it, because most people are sophisticated enough to read something and understand, right? I will even tell you where you can go to the court website to find. We have booklets on the court website, which are compiled directions, step-by-step directions on how to complete a divorce for self-represented parties. It's on the website, but if you don't know that it's there,
many of us, I don't
you
think
will
many
know.
of us know that.
Yeah, and most lawyers don't even know, but it's on there.
Wow.
Right? If you print it out, I will print it out for you. I'll give you, I was like, this is what you should do step by step by step by step. And most people succeed on that. However, most people don't have time to pursue a proceeding or a divorce action on their own, because going through that process means that you're missing work and you're missing other things, which is why they get a lawyer. Because if you have a lawyer, the lawyer does all the work for you and makes all the appearances for you, and you don't have to miss work. If you're missing work, you're not making money. And how do you sustain yourself if you're not making money?
Makes sense. Okay, so I don't really want to draw you back, but in cases, I know earlier on you said all properties are split 50-50, but in cases where we have violence, right, where one party is experiencing that, because that's part of what we do here. We advocate for families, for individuals who are going through domestic violence in any form, right? So when we have people who have actually gone through this problem and we are not at the point of divorce, is it still 50-50? I'm asking because of some of our clients who want to know. Is it still shared 50-50, or is that act considered in splitting the resources?
So property, the main principle is to divide 50-50. But like I explained earlier, it's not an automatic principle, which is why the first thing a lawyer talks to you about is compiling your financial disclosure. It's the very first step in a divorce proceeding where we have property issues and support issues. Because from the financials, you will know whether it's going to be 50-50 or there are exemptions. The main principle is that you tally and you divide. But the law also acknowledges that different cases apply. So even though we have a common rule, those exemptions, when it's claimed, will mean that you're not going 50-50.
Okay.
If there's a case where one person is alleging, I use the word alleging just because I don't outright say there's family violence. It's an allegation. And the only person who can substantiate it is the court. I will put forth the material based on my client's story and based on documentation, and then establish that based on everything that happened, family violence occurred. So if there is an allegation of family violence, in a relationship and maybe it led to the separation, it doesn't affect how property is divided. It doesn't also give you any advantage to get more money. It doesn't give you an advantage to get more spousal support. Just because when it comes to legal principles, spousal support or partner support, if the parties are not married, is based on principles that are outlined in the Divorce Act and also the Family Law Act. What are the incomes of the parties? What's the duration of the marriage? What were the circumstances of the marriage in terms of, did the wife stay home by joint decision and the party says she should not work, so now she cannot return to the workforce, she needs money to sustain herself? We have compensatory basis and non-compensatory basis. Those are the things that we look at to determine entitlement as the first factor. The second thing, we look at the incomes of both parties. You could have the right or entitlement to receive spousal support, but the husband or the wife doesn't have the money to pay you because the income is very low. So at that point, you have a right that you cannot reinforce right now. You can reserve that right and come maybe 2 years down the road to still claim spousal support. You can do that. If they have the money because their income is high, then we will calculate how much support will be payable. All of that information is entered into softwares like DivorceMate, ChildView. You will get the numbers. Property is property. I'm sorry to say, but if someone experienced violence in their family or their relationship, it's background information. But when it comes to the division of property, they are unlikely to succeed in getting a higher portion. But the issue of family violence is a factor that is determined or looked at when we come to parenting. And you can find it very clear under Section 18 of the Family Law Act or Section 16 of the Divorce Act when we talk about the best interest of the child principle. The issue of occurrence of family violence is one of the factors that the court looks at when determining what parenting arrangement is appropriate for a child or children.
Okay.
Not property.
Okay. So XT is asking, so does the family law works differently from the Divorce Act?
No, family law is the general practice. Family meaning that like we have employment law. Family law is the general. I think what she's referring to is the Family Law Act.
Okay.
Yeah. So the Family Law Act is a different document from the Divorce Act. Divorce Act is for people who were married, they have a marriage certificate. They will rely on the Divorce Act because a divorce can only come from a marriage. So all relationships, you experience a separation. But for those who are legally married, you need a divorce judgment to finalize it. If you're not legally married, you don't need a divorce judgment. You're just going through a separation and still dealing with the issues. The issues of parenting, child support, spousal support, property, we call them corollary relief from a separation. But the divorce itself is a divorce judgment, which is why I explained that a separation is not a divorce.
Okay. So,
yeah.
Michael, I see you've raising up your hand. Just type in your question or your contribution in there, and then we can talk about it. Okay. Okay. So,
sorry. One thing also, where those two provisions, so Divorce Act will apply to those who are married legally. Family Law Act is similar principles, just to those who are not married legally. However, there's a point where both acts will intersect, and that's where people were living together before they married. Because then you have two phases of that relationship. The part where they were living together as unmarried, and then they transition into a marriage. And because we are going back to the beginning of the relationship, we have to intersect. The same principles, we're just referencing both documents to cover the two different timelines. When you look at the statement of claim for divorce, it talks about relationship of interdependence. Was there a period of time when the parties were in a relationship of interdependence before the marriage? You see questions like that.
Actually, I hope that answers your question, and I hope you're satisfied with that response. So I know that there are some common mistakes in your field that you keep on seeing our people or clients, repeating all the time when it comes to divorce and sharing family properties. So what are those common mistakes so that those of us here can be properly guided?
Sorry, are you asking about common mistakes when it comes to dealing with property division?
Yes. Coming to property division, common mistakes that you see clients making all the time, repeatedly.
My first suggestion is when you experience a separation, it is advisable to speak to an expert. When you spend 30 minutes, 1 hour with a lawyer, it will provide you with clarity that you need on a go-forward basis. But when you start a process on your own without guidance or just a head start, it could become very frustrating and lengthy. That people will give up halfway. But you see that they have such a good claim. However, they've done so many wrong paperwork. It's dragged and they've disclosed information that they were not supposed to disclose or made allegations now that they have the burden to prove. But if they met with the lawyer at the beginning, the lawyer could tell them straightforward what could be relevant to the issues that they're seeking. I find that whether doing consults or presentations in the communities or just sitting in the courtroom and listening to people, especially self-represented parties, I find that they focus a lot on the background information. Because when you separate from someone, there is that hurt most times. Sometimes it's amicable. They're like, it's no longer working. You go your way, I go my way. There's an amicability. But majority of the time, separation flows from hurt, anger, grudge. And if a party doesn't understand what information is useful or relevant, it could frustrate their case. You can see documents of 8-page affidavit, which is a supporting document and application, or even a statement of claim, and everything that the person is saying, oh, he was a bad person, he cheated on me, he never, I'm going to go, because I think this is an adult platform, he never had sex with me, oh, he had so many girlfriends, oh, la, la, la. It's good storytelling. He was a drunkard, blah, 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 or she cheated on me, she was a prostitute. Good information. You're showing us, we're going to read it and we smile. When I say we, it's the court and the public, because when you file documents that open to the public, the judge is going to read that information. Is the judge going to use it? No.
No.
Is it going to make you get more money? No. Is it going to make you get more property or make your matter go faster? No. That's why you need guardians. When it comes to what you're seeking, there are principles. We have the law. Those laws are based on principles that have been set to guide the court's decision. So if the things that you're saying in your documents do not fall in line with those principles or prove your position as per those principles, well, you stand a chance of not being heard. It's not that you're not being heard, it's that you're not communicating the things that should be heard. So you're looking at the judge saying, oh, this person could be biased. No, the judge is asking you, tell me why you need spousal support. Tell me why, because we have 3 ranges of spousal support, the low end, the mid end, and the high end. They'll show different amounts based on the incomes of the parties, the duration of the marriage, if there are children, blah, blah, blah. Those calculations are there. You need to tell the court why you should be giving the mid range or the high range rather than the low range. What circumstances of your marriage, as per the provisions of the Divorce Act, Section 16, makes you feel you're entitled to get high money than low money. But if you don't understand those requirements, you would think that that person being a drunkard will make you get more support. It wouldn't.
It wouldn't.
So getting the good head start is important. It will help you understand relevance. The law of evidence flows across different practice areas: civil, family, employment, business. Evidence is the fact of collecting, disclosure, financials, materials, preparing your supporting affidavits. And those things are governed by relevance and material nature. If it's not relevant to the issues that you're seeking or material to your claim, it's just background information. And you will prepare documents and go to court, and the court is still asking you, convince me why.
Makes sense. So what you're saying in essence is that rather than us speaking to family members, speaking to our colleagues, people in our environment for answers, we have to go the legal way. We have to
go
seek
to the
professional.
expert.
Yeah, go to the experts, seek for professional help.
Yeah.
That's when we'll be properly guided with relevant documents that we need for the whole process. So we spend less money.
Yeah.
And we are not overwhelmed, emotionally. That's it. So I think we just have two more questions. Mikey, I see you, I hear you. If we have more time, I will just allow you chip in one or two things. But the question I'm about to ask is for some of our clients who, in this case, they are unable to work, right? I know we've spoken about something in this context. They're unable to work because they are the homemakers, which is not a crime. That's a job on its own.
Oh, it's a full-time job.
And then on the other hand, they are also at this point also experiencing domestic violence.
Yeah.
But because they do not have the financial capacity to go into the divorce process, they become stuck. And because they cannot pay for this whole family property division, the whole process that it entails, what advice do you think you can give to people in that category?
Now, if someone finds themselves, whether I say husband or wife, or say you're not married, I'll just say, if you find yourself after being in a cohabitation relationship and now you're separated, and say they kick you out of the house or you are not in the house, because if the property was a rental, well, it's not an own property, meaning that unless you're on the lease, well, you cannot really claim entitlement to a property that is a rental. But let's say the house was owned and there was family violence. The issue of family violence it goes beyond just family law in terms of separation, parenting, property, and all. It starts from you protecting yourself. For you to be able to protect yourself, you have to think of a protection order. We have non-criminal protection orders, and I am a strong advocate for non-criminal protection orders. Just because we are aware that when it goes to the criminal part of it, it comes with repercussions which would go a long way into the future. If that children, right? Those children will be impacted one way or another. If the mother or the father has a criminal record, cannot work in the future, is subject to all these peace bond restrictions and stuff, criminal record is bad. Most times in Canada, they won't hire you if you have a criminal record. So let's talk about the non-criminal protection orders. In situations of family violence, the first thing is to find safety. That safety could mean going to shelters like Ruth's house. Ruth's house has so many resources and is always willing to take in people. So finding safety is number one. Once safety is secured, you can obtain what we call an emergency protection order. The regular name that people refer to is EPO, right? Yeah. It's a family court order. It's not criminal, but it will give you the same restrictions in terms of The person cannot come close to you or your children if the children were witnesses to that violence, or even, they experience the violence themselves. It will give you that level of protection that you need, and it will not incur any criminal consequences unless you decide to include a criminal aspect of it. And the criminal aspect only gets involved if the police is called, because once the police is called, of course, they are concerned with criminal defense and the penal code and all. But if you're able to get an EPO, you can get it over the phone. If you Google obtaining an EPO or emergency protection order in Alberta, it will give you the phone number, every information that you need. That is granted by we call them justices of peace. They work on a rotation. That judges that deal with those things. They'll listen to you, they'll ask you questions over the phone. If you satisfy the requirements of getting an EPO, you'll be granted. A copy will be served on the person by a police officer. If the person is in the same house with you, the police officer will bring the document to the person and remove the person. But they're not taking the person to jail or detention. They're just removing them as per the order.
Mm-hmm.
There's a review date of the order, which will be like 2 weeks or 10 days after, where the other side will need to prepare their own side of the story and provide it to the court. There'll be a hearing, blah, blah, blah. If the court is satisfied that violence occurred, the court will put that order in place for up to 1 year. But at least you have that interim, so emergency protection that you need. If the person kicked you out from the house that is owned, meaning that you guys own it, whether jointly or separately, it's a family home and you're entitled to it, and you were the vulnerable party, meaning that they are likely to have more money to afford another house compared to you, you can ask the court during the EPO hearing, where you call to get that EPO, and even though you are not in the house, you could be in a shelter, you could ask the court to kick out that person so that you can return to the house.
Really?
Yes.
Oh my goodness.
Yes. So you don't have to be in the house to get an EPO. The EPO is very detailed. The court will put all the restrictions on it. It could be up to 500 meters. So if somebody is not supposed to be up to 500 meters away from you, it means that there is no way you can even do eye-to-eye contact with them.
Yeah.
Until it's determined. Those are the options. But when you go through the process, it will be explained to you, that very thorough. You will see a copy of the document, you know exactly what it is. Once you say, if you are kicked out and you return to the house, you are not there and the person is not there. So you have the privilege of staying in the house, or not privilege because you are an owner of the house as well, even though your name is not on it. You will stay in the house and, deal with other things that come forward. But the separation is the separation, and these other issues that are distinct from the issue of family violence and how to address it.
Yeah.
Right? Somebody can get kicked out of the house and still be responsible for paying the expenses of the house. That is in cases where, like you mentioned, let's go with the wife, because that's the majority of the time. The wife is the one who is a homemaker.
Yeah.
The wife was a homemaker. The husband makes a lot of money. They have children. She was the primary caregiver of the children during the marriage. Now they've separated and he's like, oh, I'm going to kick you out, blah, blah, blah. You're not on the title of the house. That story. If there was violence and she, say, goes to a shelter, what the shelter would do, like Ruth's house, what I'm aware is they have caseworkers who assist to obtain EPOs. And in that EPO, or by virtue of it, the man could be kicked out of the house and the woman return. And the man will be ordered to pay the expenses of the house because he was the financially viable one during the relationship. And he's going to continue paying for the house until all issues are resolved. Because for her to be able to get a job, she needs time. What does she do in the meantime? Like, she cannot automatically or magically have the skills to go find a job. So The husband who made a lot of money will have to find his own accommodation, but still pay the expenses of the family home until there's a final determination. You will see a lot of angry husbands in the courthouse, especially if they make a lot of money, because it comes with a lot of responsibilities after they separate, particularly if they were enjoying the fact that the wife was not working during the marriage. It's not, so if you're married for 30 years and she's not working, she's not going to start working, one day after you separate. Because if I have a client like that and she's my client, you're going to pay her thousands of dollars until,
and everything is split 50-50.
Yes. Decisions are very important and they come with consequences. Just like family violence, if you're hitting somebody, you should know that there are consequences for that. If the person decides or chooses to go just the family law route and get a protection order, good for you. It means that they are being reasonable and feeling sorry for you, because they could definitely send you to jail for that, right? So family violence is not a good thing. And the more we speak about it, I feel like there's an awareness and willingness to change.
Okay, so thank you. I think we are short on time right now. There's a question from Michael. Michael, I know we spoke about what we are looking at, resources. We mentioned legal aid and all of that, but I think we'll take the first question of can the assets in a will, because that's directly related to family division, properties division, what we're talking about today. So can the assets in a will be shared, especially if it's going to non-family members? That's what
a will is your personal document, not a family document. So I'm going to create a distinction between family law and wills and estate. Family law is regulated by the Family Law Act, family property, all of those things that we've already talked about. Wills and estate is very separate and different from family law. It's regulated by the Wills and Succession Act and other things. The difference between those two things is, in family law, we deal with relationships, brother, sister, husband, wife, girlfriend, boyfriend, cohabitation. Those rights exist between you two. So in terms of property, when you are in a relationship of cohabitation or a marriage and you separate, the law requires that you add up and you share. If you are not married, in terms of having a marriage certificate, it means that you have more exemptions compared to somebody who was married. That is different from you as an individual dealing with how you want to give out your own personal property. So a will document does not influence family property division, because a will is you deciding, I want to give my property to charity or to my dog or sell it. If I die, don't give it to my family, donate it. But it is only what you have at the time that you die.
Yeah, exactly.
Right? It's not what comes from your marriage. So wills don't influence family property division. Your will only distributes what you as an individual owns, which means that when the person dies, they look at what they own and then they pay taxes, probate, all of those things. The residual value, which is the net, is given out to the beneficiaries in the will. Your beneficiary could be your spouse. It could be your brother or sister, but that is what you own as a person. If the parties are not separated at the time that, one person dies, meaning that they're still married, certain properties are subject to automatic takeover. I'll use an example of a house. If two parties are married legally, which is why getting married is good, to have a marriage certificate is easier to argue things. And one person dies during the marriage, meaning that there was no separation, and you guys had not even discussed separation. The other person who is alive has what we call automatic right of survivorship. As a spouse, you have the right to take 100% over what your husband owns, unless there was a prenuptial agreement to say otherwise. If there was no prenup, you are taking over the real estate that the other person has, 100%, meaning that you are the spouse, right? And family law trumps the Wills and Succession Act, because you have to deal with what the two people have and the relationship first before you deal with the will, which comes after. Yes. If they're separated, then they must have divided things. So one person will have that thing and they can give it away the way that they want it.
Okay. Thank you so much. Before we end the session, I will just entertain this question from Michael, just so you add a voice to it and help with the clarification. He's saying, from social justice perspective, why is legal aid not allowing clients to make decision on their legal representation? I don't know.
Well, that is a process question, and I'm not going to put any assumption on it. Unfortunately, Legal Aid is an independent organization which has its own principles, and no lawyer has an influence on that. Neither does the court have an influence on that. I feel like when it comes to legal aid certificates and representation, they don't have lawyers. It's an organization. For example, Ruth's House is an organization, and they use lawyers on a volunteer basis. I'm one of those. What I'm doing right now is on a volunteer basis. Legal Aid is a government-funded organization. They don't have lawyers who act for you in court, like they hire those lawyers. What they do is they send out rosters to the legal community, and lawyers sign up. I've been signed up with Legal Aid since I was a student in 2021. Lawyers signed up with Legal Aid on a voluntary, discretionary basis, meaning it's a choice. We're not mandated to do it. When you sign up to be part of the Legal Aid roster, you form a group where if someone is approved for a certificate, they shoot it out to see who is available. The person who is available will pick it up. A lawyer could be unavailable just because the court date that you have coming up does not work for them, or they have a heavy caseload, so they cannot take legal aid matters. And at that point, any lawyer who is available will pick it up. But there's an aspect of choice. And I also tell clients when I do consultations with them, even when I do those 1-hour legal advice sessions through CAG Legal Guardians or on platforms like this, you can tell Legal Aid which lawyer to send your certificate to. For example, if you consult with a lawyer, or you know a lawyer that you can speak to that work, you are sure they can represent you properly, you can provide that information to Legal Aid. And if they do accept certificates, they will take on your matter. I would suggest you have a conversation with them before so that they're aware. And even if the lawyer doesn't accept legal aid certificates, but they're registered on the roster, they could still get your certificate. That's a personal choice. So the issue of choice comes in there. There are times when I have some referrals and I say, you know what, I'm able to take 2 legal aid certificates a year as allowed by my firm. So if I have those openings and someone is able to benefit from them, the person will give my information to Legal Aid, and Legal Aid will not publish the certificate on a general platform. They will send it directly to me and I'll be the lawyer. Legal Aid pays lower. So if you have a Legal Aid certificate, the lawyer is being paid 125. It used to be 100, but they've increased it now to 125 per hour. That's good subsidized amount compared to you paying $350, $400 per hour. So, Michael, the issue of choice has different forms. And that is the format in which you could apply that choice or ability to choose a lawyer. But generally, it goes to anyone who is available. And also, if a lawyer picks up your certificate and the relationship is not given, like you guys are not working together, because you have to work well with your lawyer, right? It's representation. It's an ongoing long-term relationship. You can request a change and the certificate will be canceled from this person and republished. Sometimes you see people go over and over and over from one lawyer to another. It could be a little bit frustrating, but it's the process.
Thank you so much. Thank you so much for sharing your expertise with us today. Thank you for all the information. It was very clear and really spoken in layman terms that anyone can understand. I personally have learned a lot today. So I'm really going to encourage us for the work that Ruth House is doing. We are always available 24 hours a day to provide support, to provide guidance to families experiencing domestic violence. We believe in restoration. And so we have programs like the Sisterhood Connect. We have the Brotherhood where we come together and try to discuss matters to, promote healthy relationship and to see how we can provide solutions to some of our problems through counseling. We have counseling, in-house counseling services. We also have programs for our teens, for our children. And then we have the Mandela Shelter, of course, and the Women's Shelter, which is providing guidance 24 hours a day to help our clients through their problems. Please visit our websites where you can find our contact, tell a friend to tell a friend, because it's a large community and there are people out there right now who are in dire need of, looking for a program, an organization that can help them through their crisis. Lucy, thank you once more for joining us today. I really appreciate it. All right.
No worries. Before I leave, I'm going to go back to that will question. One thing I would like to note is if someone is trying to hide property or thinking they can escape sharing property by putting in their will, the common occurrence is that you live before you die. So if a separation is a life issue because you're existing, but a will only takes effect after you die, and a will is only applicable to what you have at the time that you're dead. So a will doesn't come before property division between spouses or partners, which means it will always come after. Yeah. And that right of entitlement and sharing in property and support will always apply.
Yeah. So really, I want our audience to send some high fives because this has been very, very elaborate. I personally am sending my love reaction. Thank you so much. All right, bye for now from our end.
Thank you all for having me.
Yeah.
See you next month.
Yeah, see you next month.
And we're continuing on the same topic of property division next month. So please come with your questions and let's have a good conversation.
Yeah, sure. All right.
Okay. Thank you so much.
Bye-bye.
Bye.